She had been diagnosed with a GYN cancer, and now she was told she did not have much longer to live. Ultimately, her family brought a lawsuit on her behalf after she died. And now, during the course of the litigation, the defense tried to get the case dismissed. Why would a judge turn around and say, no, 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 not so fast, defense? There is a question of fact to be determined by a jury. You want to know what this is all about? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and let me share with you what happened in this terrible case involving a woman who was diagnosed with GYN cancer. She was told she did not have much longer to live, and now, as a result of her untimely death, her family decided to investigate to see whether or not her treating doctor, her treating gynecologist, should have recognized that there were signs and symptoms of this cancer which should have been and could have been detected earlier, which would have allowed her to get treatment earlier, which would have improved the chances that she would have survived because the cancer would have been diagnosed and treated at a much earlier stage. In fact, that's what our experts confirmed. So now, during the course of the lawsuit, the defense says, you know what? We don't think you have a valid case, and we have experts to prove it. So now they go ahead and ask the judge to dismiss our case in something known as a motion for summary judgment. A motion for summary judgment is a formal request for the judge to throw out our case. So now the judge has to evaluate the defense's papers, their argument, and their experts, and now they have to evaluate our experts and our papers in response to this. And what did the judge conclude? He concluded that this was a question of fact, not an issue of law. You see, during the litigation, the defense has every opportunity and every legal right to ask a judge to dismiss a case if there is an issue of law to be decided in their favor. However, if this is not an issue of law to be decided, but rather a factual issue about when the patient should have known, when should the doctor have recognized this, now it becomes a battle of the experts where you have competing experts battling. One side saying one thing, another saying another. That's a question of fact. And now it's up to a jury to determine who is more likely right than wrong. When it comes down to factual issues and fact-finding, then it becomes an issue for the jury to resolve, which means that it's no longer a legal issue. And then the judge turns around and says, no, 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 defense lawyer, you are incorrect. This issue has to be decided by the jury at the time of trial. So I am denying your motion to dismiss this case during the course of the litigation. And that's exactly what happened here. So why do I share this quick information with you? I share it with you because if you decide to bring a lawsuit for medical malpractice, don't be surprised when the defense turns around during the course of your litigation and tries to get your case dismissed, even though you believe you have a valid case and even though you have medical experts to support your case. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you haven't started a lawsuit yet because you're thinking about bringing one, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.